If a child gets taken from a family and placed in foster care, does a parent have any say over where that child gets placed?
Well, when the agency first is considering placing a child in foster care, they are required to make a search for relatives. Now, depending on the exigency of the circumstance, they may not be able to immediately place the child with a relative. Sometimes they will ask if there's a family friend who can immediately come over, depending on the nature of the claim. Many times they don't do that. They cannot provisionally place the child in a home that isn't licensed unless it is a relative. And in those circumstances, sometimes they will place provisionally and say subject to completing all the background checks. After that, once you get into court with the agency and the child's in foster care, you do have a right to ask the court under the Child Placement Review Act that you want your child placed in a particular home with someone who's a family friend or even a relative. And beyond that, you have very little say. So if you don't know the person that you're proposing or that person is not approved by the agency, they're going to place the child where they feel is a best placement, and you really have little say over it.
When you get into the testimony portion of what happens in these court cases, if a Child Protective Services caseworker lies during that testimony, is there anything that can be done to prove otherwise, especially since it has such serious ramifications?
Well, obviously the quality of the lawyers is going to have a great impact on what information is ultimately deemed to be true or false before the court.
That's where you come into play.
Right.
Yeah.
And we can help unearth some of that. But I always have this very candid conversation with parents about this. Judges are trying to come to the right conclusion. They're trying to make sure the child is safe. They're trying to make sure they protect the parent's constitutional rights. A lot of times,
so much to weigh
there's
here.
so much fervor that comes into these cases. Workers are many times overworked, underpaid, underutilized, over-resourced. They don't often have the expertise to delicately balance all of the factors that need to be considered. So sometimes they become overzealous. Now, there are some that just lie outright, and they become maliciously motivated toward a parent they don't like. And when that happens...
That is incredibly disconcerting to hear.
Yeah, it is, because of course they are allowed to come to your home and gather the information, and what they put down is presumed to have a high degree of reliability under the law. And so of course, if they're telling falsehoods, judges are not pleased by that. Many times I've seen judges kind of intimate, if not suggest, and sometimes outright order that a new worker be brought into the fold. But much more often than not, what ends up happening is the court takes it into credibility, takes it into account when weighing the credibility of the witness, and that can often tip the scales in your favor at trial.
So, and then we begin to get into these extended and blended family circumstances where there may be a new girlfriend, there may be a new boyfriend. What if that extra adult in your child's life has a child protective case against them? How does that impact what goes on?
Well, a lot of times when former spouses come into court and they say, I don't want my child around my ex's new person, the judge sees that as sour grapes, and they say, you're really motivated by your own animus toward your former spouse and not what's best for the child. But usually when you bring up that there is a Child Protective Services investigation or case against either person, either your former spouse or that significant other, a judge is going to look at that and be concerned that that the child is not your child, is not placed at risk by being exposed to someone. Now, of course, it requires the same type of analysis that would be required if your spouse was the one having the case, meaning you have to ask the court to compel the production of the Child Protective Services records for an in-chambers review. The judge is going to look at what the allegation is and see whether or not it has limited application to the children at issue in that case, or if it could also be extrapolated to any other child. You do have some arguments in your favor. The Child Abuse and Neglect Evidence Statute presumes that abuse of one child is prima facie evidence of abuse of another child. So you can say your child is at risk simply by virtue of there being a finding that this person has placed other children at risk, even if they were not your child.
I mean, that could be terrifying as a parent to know that your child is going into your former spouse's home and somebody there is an abuser.
Absolutely. Now, of course, I always tell people, if they come to me with a legitimate concern, I don't know what this is and I'm scared, I say, let's not ring the alarms just yet, because I know that Child Protective Services has a legal obligation to investigate every claim. So you could have an angry neighbor who just called up on your former spouse's significant other and made up some allegation, and the agency is still ferreting out whether or not that's true. So it may not be that there's some legitimate cause for concern. I mean, obviously you should raise the question. You as a parent have a right to ensure that your child is safe in the home of the other parent, but that doesn't mean that any and every allegation raised against a new person is something you should be worried about.
If Child Protective Services gets involved in your home life, in your family life, and they start to offer services, are you mandated to take advantage of those services, or is it a mere suggestion?
Well, you're never mandated to take advantage of the services until a court mandates you. That's one thing that parents absolutely have to understand. You do not have a requirement to simply take the services because they are offered. Now, that being said, the agency will often threaten, and they will make good on their threats in many cases, that if you do not accept the services, they cannot ensure the child is safe, and they will either remove the child because they now determine there's an imminent risk of harm, or they will go to court and apply for a court order. So in those circumstances, it's always best, always, to consult with an attorney to understand, is this a case where I'm truly at risk, or are they just threatening me and trying to scare me into doing something so they can dot the I's and cross the T's and close the case and saying that they've done what they needed to do. Now, once you get into court, it's a little bit different. Once the court has a case, the court immediately has the authority to order services for your child, because once the child is within the purview of the family court system, the judge has a responsibility to make sure that child is safe. As to the parents, however, the court doesn't have the authority to compel the parents to engage in services until there's been a finding that they violated the law. So a lot of parents will say to me, well, I'm ordered to do a psychological evaluation or a substance abuse evaluation. I didn't know that I didn't have to do that, and now I've been told that I've done it, so it's going to be used against me. And I say to them, once you've either agreed or the court has ordered it and you've complied, it's kind of hard to unring the bell. So you really want to say no at the outset if you're going to say no, but you don't want to say no as a knee-jerk fashion, because in many circumstances, once your child goes into foster care, you got that ticking time bomb. If you don't get these issues resolved within a relatively short period of time, about 1 year, you're looking at the agency moving forward to try to terminate your parental rights. So you don't want to take a risk on not doing any form of services. You really should speak with an attorney as to whether or not you're going to engage in the services privately, or if you're going to accept the state-sponsored services, and if so, what information is going to be released from those services to the agency to be used against you.
All the more reason why you should be having a consultation with a really knowledgeable attorney to make sure that your rights and your child's rights are fully protected.
Absolutely.
Another layer to the whole family dynamic often is grandparents. We've seen cases where grandparents have been court mandated to have visitation with children, even though perhaps one parent's parental rights have been terminated. We've seen cases where grandparents raise grandchildren. How does that all come into play?
Well, a lot of grandparents come into the family court system when there's a Child Protective Services case and they want custody. And what I always tell grandparents is, once the state has custody, it's almost impossible for you to get custody. I mean, the court is not going to remove custody from the agency and give it to a third party, because the state having custody is the guillotine that parents often require in order to get their act together so that they can safely parent. And that is who the court is going to be concerned with for the child, the parent, and not third parties. That being said, if a grandparent has a strong enough relationship with the child, that grandparent can come into court and apply for visitation, depending on the extent of their relationship. And many times, if they have had a significant enough relationship, particularly if you have an absent parent, if you have a father who's out of the picture, and a grandfather has kind of served in the role of father for the child, you may even qualify as a psychological parent, in which case you could be joined in the action and participate depending on the circumstances. So grandparents do have rights. They have a little bit more than just a family friend or someone who might want to have access to the child, but it certainly is not a viable contest between the state and the grandparent for custody.
And when we talk about those visitation rights, if a child gets removed and put into foster care, how much visitation does the parent get? Is there a cut and dry formula, or is it a case by case?
Well, I mean, the general standard, and unfortunately there's no formula, but the general standard is that they're supposed to have reasonable visitation designed to effectuate the case goal. So if the case goal is reunification, they're supposed to have reasonable visitation. In my experience, if the visitation happens at the agency office, it's probably going to be 1 to 2 hours a week. which is, of course, abysmal. For very young children, children who are preschool age and younger, there is a regulatory presumption that they are to have frequent visitation of long duration. And so a lot of times parents come in and say, I have an infant, my 2-year-old is in the custody of the state and is placed with a foster parent. I don't know where my child is, and I'm only seeing my child 1 hour a week. Almost invariably, if you go into court with those series of facts, the court is going to give you more visitation. So the goal that you always have when your child is involved with the system is to see that you have relatives, friends, or even third parties who may not be able to have the child in their home. They're not willing to be foster parents. Maybe they don't have the resources. Maybe they don't have the space. But they can still be approved to supervise visitation. So you could have friends and family members help you in that way to effectuate more liberal visitation. And that's for children of any age. So once you go into court, if the child has a relationship with a parent that is not harming them at the moment, i.e. the child does not detest going with mom or dad, they don't feel harmed simply by being in the presence of mom or dad, but there are concerns about mom or dad's mental well-being, substance abuse, issues like that, that the state wants to safeguard against, then usually you can get some third party approved to supervise.